Hello, everyone, and welcome to the Pump Act, What Employers Need to Know. Today, we're joined by the CEO of Healthy Horizons and Cara. We'll do introductions on the next slide, but thank you so much, everyone, for joining. Today, we're going to talk about this brand new federal workplace lactation law and give you some actionable takeaways at the end. My name is Cassi Janakos. I'm the Chief Operating Officer of Healthy Horizons. I've been with the company for nearly a decade, and I specialize in working with our corporate partners to create consistent programs across North America. And we also have Sheila on the line. Sheila, can you please introduce yourself?
Yes, I'm Sheila Janakos. I'm the CEO of Healthy Horizons. I'm also a board certified lactation consultant, and my specialty and my favorite topic is workplace lactation.
Hi, everyone. My name is Cara Barrick. I'm an attorney in the San Francisco office of Ogletree Deakins. I am so privileged that Healthy Horizons, Cassi and Sheila invited me to join them today to speak with you about this latest in the law. In this instance, the Pump Act. I also hold several HR-related certifications from SHRM and from HRCI, and I'm really happy to be here.
So let's get down to it. We're going to be talking about the Pump Act. And so what does that mean? What is the Pump Act terminology? Well, the full name of the law is Providing Urgent Maternal Protections for Nursing Mothers Act, which is a mouthful. It's also known as the Pump for Nursing Mothers Act. So you'll hear it either way. It means the same thing. So back in 2010, and this was part of the Affordable Care Act, they passed the Reasonable Break Time for Nursing Mothers provision, which became part of the Fair Labor Standards Act, which really is the FLSA. You'll hear that term. And really what that organization does is it provides, it's a federal law, which sets like minimum wage, overtime, record keeping, and oversees like youth employment standards. So it's an important law that we have, and we're lucky that we have that here in the United States. But part of this act, it was protecting nursing mothers, gave them protections at work, but it didn't protect everybody. And we'll talk more about that in future slides. But in 2022, Congress passed this Pump Act, which became enforceable April 28th. And that amends this Fair Labor Standards Act, and it gives employees more rights and more protections and also remedies if there is a violation. So that part's good. And really what this is doing is it's taking care of the provision where an expressing parent is able to provide milk for their baby for a year and have protections. So that part's great. And we're going to talk more about what that means and what those protections are.
So what's new? What brings us here together today to talk with you about this change in the law? Because there, as Sheila just said, there were existing protections. Since 2010, federal law has provided some lactation accommodations for break time and for locations for people who need to express breast milk in the workplace. That was already the law. And in many states, there are also state laws that protect people and provide those accommodations as well, break time and locations. What's new? Well, there was a gap in the law that was passed in 2010 where it didn't protect everyone from under the federal law. It only protected non-exempt workers, not exempt workers. And I'll talk in a minute about what that means. So since the new law was passed in 2022, approximately 9 million more people have the protection of the law. What are some examples, just by way of example, under federal law of some types of workers that now have this protection. They could include nurses, teachers, people in the agricultural industry, home care workers, different types of management level employees, particularly, for example, in retail managers, restaurant industry managers, people who are properly classified as exempt under the Fair Labor Standards Act. So let's just talk about that for just a second, and we'll come back to it. But to be exempt under federal law requires two different considerations. One is workers have to be paid on a salary basis, not hourly, and they have to be paid a certain amount, and that amount is set by federal law. But they also have to engage in certain types of job duties. And you might have heard executive or administrative or professional exemption categories. Those are just a few of the overall exemption categories under federal law. And each of those, executive, administrative, professional, has different job duties tests. And so as a practical matter, where someone who was classified as exempt, maybe in some instances, they already had the freedom within their workday or within their position at work to take the lactation break time that they needed to find a location. Maybe they had their own office and they were able to close the door. Folks in those types of positions, they weren't specifically protected under the law. So if you did have someone who was exempt, for example, a registered nurse under federal law, and they were not able to have that flexibility within their own workplace for break time or location, now federal law would specifically include them in its protections. So what this does is it helps focus employers on, considering whether someone is non-exempt or exempt, but now recognizing that under federal law, everyone is protected for a lactation accommodation. Just a footnote that under some states' laws, including California in particular, the definitions of exempt or non-exempt workers are different than under federal law. So a lot of what we're talking about today won't apply or will be different in some states like California. Just wanted to mention that so you keep that in mind.
Okay, wonderful. And then it does exclude some workers, such as airline flight crew and pilots and flight attendants.
That's right. And so not 100% of all people working in the United States are covered. As we just saw, some people are excluded or they'll be added at a later date. But for the most part, many people that were not covered before are now covered. And another change that's different are some changes in the remedies that people can seek if they feel that their employer is not compliant. So again, we're just looking at federal law. So under the new Pump Act amendment, what employees can do if they feel that they're not getting the accommodation they need is they can either file a complaint with the Federal Department of Labor, or they can take private legal action, meaning file a lawsuit or proceed to arbitration, depending on the situation. So compliance is always been important. It's always important to do the right thing and give people the accommodations that they need to have healthy babies and be healthy moms. But now, if that's not already getting businesses to be compliant, a few more things to be afraid of might help. One of those is that some of the remedies include reinstatement, employment, promotions for people that feel that they were retaliated against, for example, payment of lost wages, possibly liquidated damages, a whole host of monetary penalties. And one thing also to remember is that under this new federal law, if particularly focused on the location aspect, not the break time, but just focusing on the location aspect, if an employee feels that they are not receiving a location to as part of their lactation accommodation that complies with the law, and we'll talk about that in a second, what it means to have a compliant location, the employee can give the employer 10 days notice to come into compliance before that employee can even bring a private legal action. And this is a gift, right? Because an employer can at least have notice and an opportunity to make the correction to the extent that they can, to come into compliance and have a compliant location for the worker. And what does this mean? To have some ideas in place, have a solution in place, because 10 days, even though it's good to have that notice, is not a lot of time to really come up with a complex engineering solution or add an additional room, right? Folks like Healthy Horizons, I'm going to just give you a shout out for just a second. They can help with compliance solutions like that, locations, temporary locations, for example, and that's the service that they provide. But you really don't want to be pushed up against the wire in order to do that, and give it some thought first.
Yeah, that's a great point, Cara. I mean, getting ahead of it and being proactive is so important. I mean, all of our clients who are doing that and are thinking about it now and assessing where there are gaps are, going to avoid so many issues down the road.
And before we talk a little bit more, and I pass it back to Sheila and Cassi to talk about what exactly the compliance would look and feel like, I just want to talk about the legal concepts of retaliation. Retaliation was already prohibited by existing law, and it's still prohibited by the new law. And so what does that mean? What does that look like? If someone requests a lactation accommodation, for example, break time, for example, a compliant location, and they are punished because they made this request, or because they used these breaks, because they took that time off or during their day to express breast milk, if they are punished because of that, that is against the law. And that retaliation can actually be more consequential. A claim of retaliation can be more consequential to an employer than the failure to give the accommodation in the first place. So, in one case, a jury awarded $50,000 for failure to provide a proper place. And that same jury awarded $1.85 million for retaliation. So to quantify those experiences for people, juries will take retaliation just as seriously as the need for the accommodation itself.
Yeah, it's really interesting with the lawsuits, because we've heard of lawsuits ranging from 20,000 all the way up to almost 4 million for a single parent, which is so much more expensive than getting into compliance in the first place.
Yeah, I also find it interesting that for each time that parents may be denied the right to go to a room and to an express, that's a violation. So if you do that over a month and the person was going to express 3 times a day, those are a lot of violations. Mm-hmm. It could really add up.
And so what are some of the things that stayed the same? First of all, number of employees doesn't make a difference. Most employers will still need to comply unless there is some sort of undue hardship that they can prove. And this hasn't been very common from what we've seen with our clients and the companies we work with. But if a company does have less than 50 employees, they could theoretically get an excuse due to undue hardship. Another thing that stayed the same is it covers the employee 1 year after the child's birth. So that 1 year timeline is the same, although in some states it is longer. So that's where it is also really important to look at that state law or municipal law as well. And of course, it doesn't preempt any state or municipal laws that provide greater protections. And more than half the states in the US have greater protections. So you'll always have to do what's strictest from each law to make sure you're complying. Some key dates, of course, this was signed into law December 29th, 2022. The PUMP Act has their new remedies available very recently, April 28th, 2023, and December 29th, 2025. There'll be coverage for motor coach and railway employees. Right now, there's a little bit of a lag in supporting those employees, but that's going to come, in a couple of years, which will be here sooner than we think.
And so just what is a motor coach? A motor coach, because it's not a word that I use every day specifically. It's defined as an over-the-road bus, which is a type of bus that has an elevated passenger deck located over a baggage compartment, but not a public bus or a school bus. So still not all bus drivers.
Yeah, that's a great clarification.
So what are the expectations for the breaks themselves? And there's a lot to go over here. So, the first thing to remember is that pumping breaks must be paid if the employee is not completely relieved from their duties. What does that mean? It means that if somebody is pumping while they're working, they still need to be paid. Even if you are telling someone that they can take a break, but they're not taking the break and they're working through that time, they need to be paid. And certainly they are encouraged to and offered the opportunity to be completely relieved from their duties. But some people might be in a situation where they, don't want to or don't need to stop. Either way, just remember the breaks. If someone is working during their break, must be paid. And this is really important for non-exempt employees, and it's important for people to know the difference between exempt and non-exempt employees and their own workforces, so that they can help determine and make sure that people are being accurately paid. Nursing parents can take pumping breaks as often as needed. So, and Sheila and Cassi, maybe you can speak a little bit more to this, because not everybody is familiar with the experience of lactation. They've not experienced it themselves. They don't have any friends or family that have done it. Can you describe what this means and in reality that someone needs to pump as often as needed?
Absolutely. Early on in a person's lactation journey, oftentimes expression needs to happen quite frequently to keep the milk supply up. So that's one factor. But if a person is used to pumping on a regular schedule or feeding the baby directly, and then all of a sudden has to spread out that expression time or feeding time and misses a break, they're going to be in trouble. They could have a response in their body called engorgement, which could be swelling. The milk could get backed up. They could have a plugged duct, even get a breast infection. So there's serious consequences to not being able to effectively or be given the opportunity to express the milk. So it's more than just a nice convenience. It's a physiological need that people have to do if they're going to stay healthy and be able to produce the milk for their baby. One thing that Cassi and I hear a lot is, can they limit the time? Like, can they just have a 15-minute break or a 20-minute break or half an hour? And they can't, because everybody is going to have a different experience on how much time it takes for that individual to be able to express milk. So some people may take 40 minutes. It's really going to be individual.
And if someone doesn't express milk when they need to express milk, can they be physically uncomfortable?
They could be in pain, a lot of pain. I hate to use analogy, but it's like needing to use the restroom and you're not allowed, and you would have you would have pain associated with that. But it goes one step further with lactation. You could actually get sick. You could get a breast infection. You could lose your milk. So it is serious. And I think that people don't understand that there's this whole side to this. And thank you, Cara, for bringing that up.
Yeah, I mean, and we'll get to training issues as well. But I know that when I'm training people, in all types of industries and all different levels of management and life experiences, this concept of, needing a break as often as needed, they just don't know. And it's not because they're not being caring or nice. They just don't know that this is necessary. And so, using these analogies and explanations and medical consequences are, all different ways of training your own workforces to explain why this is really important. It's not like, somebody just wants to take a break and hang out with that's just not what it is.
Yeah. Nobody's going to want to hang out with their pump for fun. Trust me.
Yes. Right.
But one thing is that most people don't realize that it may be more time intensive in the beginning, but as that baby grows and gets older, these pumping sessions may go from 3 to 4 a day to 3 to 2 to 2 to 1 to 1 and then to 0. So typically most people by a year to 15, 14 months are not pumping during the day. Some people may pump until 2 or longer, but this is kind of the average. So sometimes it's good to kind of wrap your head around what the typical is, so you have a better idea of what the person's needs may be.
And, as you mentioned a few minutes ago, the law really does only apply for 1 year after the birth of the baby. Employers can certainly extend the accommodations, but if we're just looking at what the federal law requires, and state law may be different in your state as well, but the federal law only requires the accommodations for 1 year after the birth of the baby. So if that's, there is an end under the law, at least for the accommodations. And then do you, in your experience, as far as these breaks go, are people able to at least understanding that it may vary as time goes on, but are people in the workplace able to at least try to schedule them to say, okay, let's try it at 10 a.m., 1 p.m., and 4 p.m. Is that something that makes sense to try?
Yes, many people do that. But one of the caveats is that if there's other people pumping, a lot of people stay on those same schedules. So these rooms can get really impacted. So that's something to also think about. So sometimes we're going to need more rooms and more spaces, because if everybody's pumping at lunchtime, 10 o'clock, we're going to need more accommodations. And we want to make sure we provide that.
And we'll get to locations, I think, on the next slides. While we're still on the break time, though, as I mentioned a few minutes ago, breaks for non-exempt employees, if someone's working through their break, they always need to be paid. But a non-exempt employee, their lactation accommodation break can be unpaid if they're using an existing paid break, though. For example, it still needs to be paid. So I'll give you an example of that. In California, people get a rest break, right? They get normally, depending on your work schedule, you normally get 2 10-minute paid rest breaks during your workday. So if a worker wants to use her existing paid rest break, that's 10 minutes to pump, that time would be paid because it's already being paid. That's easy. If, however, as Sheila and I were just talking, someone's taking a 9 a.m. break, an 11 a.m. break, 2 p.m. break, and they're a non-exempt worker, and those are not otherwise scheduled paid breaks, then that non-exempt employee does not need to be paid for that break time under normal circumstances. Exempt employees, such as your true managers, architects, engineers, lawyers, doctors, teachers under federal law registered nurses, usually, exempt employees, they're being paid anyway because they're being paid on a salary basis, and you're not going to dock their pay just because they're taking a lactation accommodation break. That's how the law is set up now. And unless and until that changes, that's something to keep in mind as well. So, this person might be taking breaks, but as a practical matter, depending on the job, especially in the desk type job, that worker might be working through their break anyway, and they're exempt, they're being paid regardless. So this is just another reminder to be mindful of whether your workers are classified properly as exempt or non-exempt, which isn't something that you probably expected we were going to talk about today during lactation accommodation seminar, but it's an important part of this new law.
Thanks for clarifying that. So let's talk about some expectations for lactation rooms. It cannot be a bathroom. We still to this day have people calling us telling us that the only accommodation they're going to have is a bathroom, and that is not okay under this law. The pumping space has to be shielded from view, so people cannot walk in on you. You're not going to have to worry about sitting there with your top off and pump in your hand and somebody opening a door. None of that should happen. The door needs to be able to lock, and it's really great to have a sign that says, occupied in use as that extra layer of protection. Now, if somebody is doing a hybrid work or working from home, these protections still extend to that person. So if they're on video calls all day long, they have the right to turn that video off and not have people watching them pump. Hopefully somebody would arrange the meetings away from their pumping schedules. And remember, they would be paid for that, right, Cara?
Well, right. And so if someone is taking a break, then that worker has, the responsibility to say, I'm taking a break, to organize the break, to communicate properly with their management team about the break or with their colleagues about the break, turn their camera off, and take the break. They're allowed to take the break, under most circumstances. If, on the other hand, and I think this is something we might talk about a little bit later, so I don't want to get too far ahead. But if someone is choosing to work while pumping, then they need to be mindful of what they're doing, because they are working and other people are expecting them to be working if they're not actually taking the breaks. So there needs to be a lot of communication and planning on both sides. And if the meeting can't be rescheduled and it has to be on video, then the employee should properly take their break instead of trying to work through it and do everything all at once. Does that make sense?
Absolutely. And some other examples of what an expectation would be is, a chair, a surface for the pump, and obviously an outlet. Most pumps are going to be electric. And so that's the standard. You're going to have to be able to use electricity. Now, note that there might be city, municipal, and state laws that have much more strict and additional requirements, but these are the basic ones.
And California is one of those, by the way, that has requirements that there be access, to either a refrigerator or another cooling device, for example. So make sure to check your state laws for additional requirements. And
then
in New York,
city laws, right? The city laws are even stricter sometimes.
Yeah,
there's
like
a new
San
law.
Francisco has wording around square footage for the room, which is very detailed. So great point to look at the state laws.
And in New York, there's a new law that the room must be well lit.
That's interesting. In the past, I've seen many lactation rooms be very dim, and I think they were trying to make a relaxing environment. So that's very interesting. I like that. Okay. So these are recommendations that we have for lactation rooms. We really recommend that it's a dedicated room, not a shared space or a wellness room, because if somebody's in there with a headache or they're sick and a pumping person needs to use it, that sick person needs to leave, because the expression is going to be what the person is. They have the right to be there doing that, right? So it's going to be, need to make it available. We want to have a comfortable chair. I would recommend one that is not cloth, because nothing worse than milk stains all over a chair. It should be wipeable. 2 surfaces. People like to have their personal items, maybe their laptop, and then also you would need a place for the pump, on-site storage, so they could leave their pieces there and not be dragging things back and forth. The refrigerator, which Cara talked about earlier, that California does require some sort of cooling device. A sink, so everything could be washed in the room and the person doesn't need to walk through the offices with their pieces. A microwave in case they wanted to steam sterilize their pump parts. And then pumping essentials like maybe the kit, maybe bra pads, maybe snacks, things that would make lactation a little bit easier. And then the hospital grade pump, which will allow the person to pump much quicker and much more efficiently and not have to, again, be bringing their pump back and forth. And then we want to make sure there's enough space to accommodate all the employees. As we were talking earlier, if everybody's taking their breaks at the same time, we may need to have extra rooms. We also recommend training the management and HR and the facilities teams who may be taking care of these rooms on what these requirements, what recommendations are, and what they should be doing to really stay in compliance, but also to make this a good experience for the pumping person. And then the last piece is making sure that room is serviced. You know, the pump is taken care of, the items are stocked, and the room is in compliance.
Yeah, and that's one piece we see some companies missing is they set up a really beautiful space that's compliant. The parents are really happy. And then 3 to 6 months later, like it needs some love and some attention. And that's one of the things we help with. Okay, some takeaways for employers. So first of all, understand the importance of the Pump Act. Like our CEO Sheila said, you know, it really is a physiological need and something that, you know, has to be supported when a parent is pumping and lactating. You know, have a written lactation accommodation policy in your employee handbook. You know, it's also great to have this with your leave packet and in other places so that parents know what to expect. And if they have any questions, they can ask you about that or help you even improve your program. Third, educate and train your team. This doesn't have to be a giant training. It can be as simple as, you know, a 15-minute presentation for managers or people interacting with lactating employees so they know how to support them. They know what to say. They know what the tools and resources are. That can go such a long way. Evaluate your sites, your offices, the way your employees work to make sure you're compliant. And if you're not, get into compliance so that you can avoid any issues down the road. I can't stress enough how important it is to be proactive. It's so much easier to do this in advance before you have an unhappy parent in your workplace. And then lastly, if there is a complaint, you know, make sure that you're responding really quickly with that 10 calendar days to get a solution. I know that can be quite fast, especially for larger employers. So be ready for that piece of it. And, you know, use a service like Healthy Horizons, where we've done this many, many times. We're here to help you implement, upgrade, and make this as easy as possible.
Cassie, if I could just add to the a couple of the points on there. For example, number 2, having a written lactation accommodation policy in your employee handbook. In some locations like California, that's actually required by California state law that you have a written lactation accommodation policy. But it's a good idea anyway, so that employees know what their rights and benefits are, and so that management knows what the expectation is of them. And so that it's very clear to everyone up front who the contact people are if they need help, whether that's someone in HR or if your organization is small and you don't have an HR department, that there's still a person that employees can contact if they have questions or concerns about what to do. And so having that in writing is recommended and in some instances required. And to the point, which is in bold, educate and train your team. We can't stress this enough. Seminars like this are certainly important, but they require someone to want to be here, right? And not all of your employees are going to say, oh, hey, I'm going to take a break out of my day and watch the Healthy Horizons, webinar, right? This is for people who want to say, okay, what do I need to do? How can I help? But for many of your team members, they just don't even know that they have to do this at all. And so, like Cassi said, a 15-minute training, showing them around, showing people the lactation space, even if they will never, ever need it themselves, so they're comfortable with it. Explaining why it's necessary, that, in a simple, easygoing, positive way, to help moms and help babies. They all want to do that. And so educating and training is the one thing that you can do to really help everyone on your team.
And then just one thing about the policy, I encourage people to take a look at your policy and see if it needs to be updated, see what it says. It became part of the ACA in 2010 that we had to have policies, but most companies didn't even do that or think about it. And now it's really out there. We need to really be doing this because that's going to be what you're going to fall back on if there's an issue, right? So that policy is really important.
And for additional resources, we put together some links for you that will be added to our social channels. First, if you need help implementing a solution, we have our For Employers page. You can learn more from our Pump Act blog. Ogletree also has a blog on the Pump Act that you can reference. We have the DOL FAQ sheet that has some great information in there, as well as the Pump Act itself. So you can see the direct text of that in Division KK. It's a very long document, but it's in there. It has some great insight. Okay, and with that, we're going to open it up for questions. If you have any questions that you aren't able to answer or ask today or get an answer for today, feel free to email us. Our email is services@hh-bc.com, or you can also submit an inquiry on our website, healthyhorizons.com. You can also contact Cara at cara.barrick@ogletree.com. And with that, we're going to open it up for some questions. Okay, so first question is, are there any considerations for remote employers? Do you recommend having a no questions asked camera off policy, for example? I often breastfeed at work without anyone realizing it just by turning off my camera. But I can see this being difficult for mothers who work at companies that require camera on during meetings.
We talked a little bit about this earlier, right? And so hopefully we can just add out a little bit more information in the context of this specific question. For an employer, I don't know if I would recommend a no questions asked, cameras off policy for the purpose of compliance with a particular law. There might be instances where if they're at a meeting, they're not on a break, as I mentioned earlier. So if someone needs the break, they should take the break. And if, in instances where they need to meet face to face, it depends on the context of the meeting as well, right? Is it a client presentation? Or is it, just catching up on things to do? Also, look, you can make it a phone call instead of a video conference in some instances, right? We can still pick up the phone. So there's a lot of other options, but I'm not sure that that I would recommend a no questions asked cameras off policy.
I think another piece of that is culture. We want to make sure as employers we're creating a culture that allows for true breaks where, other employees or managers won't push back for that lactating parent. Because I think that's another big piece of it is people feel like they always have to be on, they always have to be working in some way. So another approach is, making sure it's known that breaks are totally acceptable.
I see a question in the chat, and I actually want to field that if you guys don't mind. The question is there a suggested way to submit a 10-day accommodation request? So I want to clarify the premise of the question and then answer it. What the 10 days stands for under the Pump Act is that if an employer didn't provide an accommodation, if it was requested and the employer didn't provide a location that's compliant, given the opportunity to do so, that's when an employee would say, hey, I'm giving you 10 days to follow up, right? It doesn't start with, hey, employer, I need a lactation accommodation and you have 10 days to do it. That's not the first stage. It's a later stage. The first stage is engaging in an interactive process between the employee and the employer. Now, in some states like California, in some locations like San Francisco, the timing of this can be regulated, but it doesn't under the Federal Pump Act start with this 10-day limit. Where it starts is given the employer's policy. If there is a policy, it'll usually say something like, if you need a lactation accommodation, talk to your HR department or talk to your immediate supervisor and try to work out something that's mutually convenient, right? That makes sense, that complies with the law. Try to work together. Then under the federal law, if you can't make it work, is when the 10-day compliance notice only for the location would come into play. So whatever your employer's policies are, follow them. If there's no written policy, contact HR. If there's no written policy and there's no HR, contact your immediate supervisor is the way that I would suggest an employee go about seeking a lactation accommodation. I hope that answers the question. Did you guys, sorry, I'm not sure if there was another question before that, but I wanted to make sure that we got that one in.
Yeah, I mean, that's a great question. That's another reason why having that policy is so important. So people are going through the proper channel so it doesn't get to like a formal complaint. So that's a great clarification. So next question is how to support employees that meet resistance from small business owners.
Sheila, do you want us to take this one?
Well, I always like to start with the path of least resistance. So I would, just like you were saying, talk to the people first. Explain why this is important. I don't usually start with the law. I start with why it's important, and hopefully the person will just want to do the right thing before you have to throw the law in their face. They may not know. They may not understand. They may think the person just wants more breaks. So I think that educating them would be the first step before any legal action. And then the next step would probably be like showing them the law and explaining it to them. Hopefully there is somebody else who works at that business who can maybe be your advocate. Maybe there is a manager that you trust that you could talk to, and they could talk to the small business owner first. So that's where I would start.
And to add to that, from the legal perspective, because again, we use this interactive process. We use it in a different context where we talk about disability accommodations, and that same interactive process concept comes up in lactation accommodations as well. And so, I suggest for employees, because I represent employers, right? Those are my clients. And it's always good when the employer, I say, ask them what they need. Like I'll tell the employer to ask the worker, what do you need? Like, so it's really helpful when the employee comes with some ideas for solutions of what would work for them. Maybe that's not ultimately what gets implemented, but if you come and say, you know, look, here's what would work for me. Here's why I need this. Can we make this work? Instead of just the law requires you to give me a break and a location. You know, it's helpful when the employee engages in the process with some ideas and suggestions.
Because they may know more than the employer. They may have some good ideas.
Absolutely. If there's a piece of equipment that needs to be purchased, the employer might not have the first clue where to start. And it's, you know, yeah, it's really helpful if the employee comes, you know, with the link to the website where whatever this item is needs to come from, or, hey, you know, I need an extension cord, guys. There's an outlet over there. You know, could you just get an extension cord and we'll be good? I mean, that's easy enough. Just tell people what you need.
Right.
And then last question. We already have a lactation room in our offices and a policy. What do we need to do? So I think this is a really great question because, you know, at first glance, that appears that you're all set, but there could be a lot of things that you still do need to do. So one, you know, make sure there's enough space. If you have multiple parents pumping, you know, you may not have adequate rooms and, you know, may not be in compliance because no one can access the spaces when they need to because they're all taking that break at 12:30 p.m. You could also look for gaps like in your policy and coverage. So with the new law, making sure that, you know, the policy covers exempt and non-exempt, for example, making sure there's, you know, maintenance for your program, that it really is staying compliant, that you do have a nice space for these parents, and, you know, prevent issues by training people that you have the room, showing them the rooms, showing them the policy, and making sure everyone's on the same page so no issues arise. And making sure that support's also consistent across sites. So for some companies, we'll see, you know, they have a really great program in California and New York, and maybe they don't have a great program in Texas or in another state. And making sure that it's really consistent so parents are getting the same level of support no matter where they are in the US. And there's so much more we could go through with that, but that's something I'd love, you know, to talk about offline if you have more questions about that piece of it and help find some solutions. Any final questions before we log off for today?
Cassie and Sheila, I just want to thank you both for inviting me to participate with you in this webinar. And it's been great for me. And I always learn a lot from Healthy Horizons. So thank you so much.
Oh, thank you so much, Cara. It's a pleasure to have you join us today. And thank you to all the viewers out there that joined us for the webinar today. If you need anything, please reach out to Healthy Horizons. We're here to support you through this.